Marcus, it's actually a question I posted myself. I posted it because I wanted to hear also the idea of the other firms on the island, what they think about it. Yeah. In general, why I posted this question is because we have this question coming in nearly every day right now. People have companies set up, we have 7 shareholders, they know the law allows now to have only 3, and the question always comes, shall I change or shouldn't I? Why should I change? Yeah. I mean, for us, it's a business. Yeah. Change of shareholders, we earn some money. So the recommendation normally is, yes, you shall change. But you have to look at your individual situation in your company. If your company has shareholders which are real shareholders, evidence of paid up money, where these funds are from, so there will never be the question of this being any nominees or not. The question would be, how can you change? Because you cannot just change your shareholders. Kick 5 out or 3 or 4, it doesn't work as long as they don't consent to it. So the individual situation of a company is important. If you have the opportunity though, if your company is not conformed with the law, I would recommend to change and do it in a way that you clean up the shareholdings, change the old shareholders to new ones, sell the shares, have evidence of funding, where is the funding from, bank account copies and so forth. So if the government is coming to check on your shareholders, especially the Thai shareholders, all the evidence is there that these are no nominees, shareholders had their money, shareholders paid for their shares, if in second hand they purchase it from the previous shareholder. So in that way my recommendation would be then, yes, if everything is in your company right, why should you and how could you? This is my view, and I want to give the microphone on because I think it's interesting for everybody who also hear the opportunity.
Yeah, nominee shareholder, I think widely used expression. Question, what is a nominee shareholder? A nominee shareholder is basically a puppet shareholder, which is not real, which is just used to fill up the shareholders list, as we've discussed before. That's why probably a lot of people want to change their shareholders now from 7 to 3. What would be the defining criteria for a nominee shareholder? Just to mention some of them, a nominee shareholder is basically a person who doesn't really have a genuine interest in the business itself. A nominee shareholder is somebody who is not able to pay up his share capital financially. The classic is you have your maid and your guardian capital of 40 baht, and if they only have one, they should be able to pay up their share capital, but probably they are not with regards to the income they earn. So that would be one criteria for a shareholder. They are not financially capable to pay up for the shares. Another criteria would be, or an indicator for a nominee shareholder, blank signed transfer forms. That means that you can take them off the shareholders list whenever you want. So let's say you fire your gardener who is on the shareholders list, so you don't even have to ask him to give back the shares, but you just submit the pre-signed share transfer form to the NOC. That would be indicators for a nominee shareholder. But I'm sure, like my colleagues here, they have some other criteria to add to this. The next question, can a company still buy land? Well, basically, if we're talking about a Thai company, the answer is yes, if the company is set up correctly in accordance with the law, of course. Probably the question more precisely should be, can a company with foreign investment or foreign shareholders buy land? And again, the answer is yes. A Thai company with foreign shareholders can buy land subject to compliance again with Thai laws, which would mean that the Thai shareholders are real investors that are not only used by the foreign shareholders to control the company and to actually own the land in the Thai company. Because as was mentioned before, the Thai land code definitely says, and clearly says, foreigners are not allowed to own land, and a Thai company which would be controlled or owned more than 49% by foreign shareholders is deemed to be a foreigner and not anymore a Thai company which would be allowed to own land. Another possible answer to this question would be a company can buy land if you, for example, have a company under BOI status. Then it might be that you, as a foreign shareholder, have even a higher percentage than 49%, which the Foreign Business Act stipulates, and you still would be able and allowed under law to own land.
Extremely valid questions and answers. We do apologize for the low video and sound quality there.